Hi, everyone. Welcome to our training session on cross-examination. We have our two presenters today, Judge Jessica Lorello and Christina Schindley, and I will allow them to introduce themselves and get the training going. As with our other trainings, if you have questions, feel free to write something in the chat or, just stop at a break and ask whatever questions you have. So thank you all for being here, and I'll give it to our presenters to go ahead.
Do you want to start?
Well, I can start, although, well, I guess that makes sense. Since you're the first presenter, you can just go from your introduction to your presentation. I'm Jessica Lorello. I am currently a judge on the Idaho Court of Appeals, but also a member of the Law Related Education Committee, of the Mock Trial Problem Writing. I don't know if it's a committee, I'll call it a group. Have been a long time fan and supporter of mock trial in the role as coach, judge, problem writer. I think that covers everything. So thank you all for attending these webinars.
Thank you, Judge. So my name is Christina Schindley. I'm a Deputy Attorney General. I have been with the Office of the Attorney General for a few years, and I've had a couple different assignments. Currently, I'm assigned to the Idaho Department of Correction. Previously, I was at Special Prosecutions. So most of my career, I've been a criminal prosecutor or an agency representative. So that is my background. When it comes to mock trial, I have been a coach at a couple different schools. I am not coaching this year, but I did coach the last several years at Centennial. And then years ago, I coached at Mountain Home. That's been more years ago than I can even remember. And I am also a firm advocate for the program. I think it is a great civility builder. And I think it's just a great way for students to become involved in the justice system and in civics education. So I think it's a very good program. Judge Lorello and I are going to spend a few minutes this afternoon talking about cross-examination. And specifically, we've kind of tag teamed it. So we're going to address some areas and some concerns and considerations from the teen attorney's perspective, and then also from a teen witness's perspective. So the first topic we're going to cover is some pointers for teen attorney preparation and presentation, just kind of generalities. So the first thing that I think is important is just a practice point. First, one of the things that might make it easiest for the teen attorneys is if the same attorneys are on both sides of the equation. So they are attorneys on both sides of the problem, then whoever they direct for their case in chief, it would make sense for them to prepare and cross-examine the same witness on the opposing side. That way, they are more likely to understand the facts and to really kind of deep delve into the problem and into that witness's statement. So that's just a practice point. If at all possible, the same attorney should cover the same witness, regardless of which side of the equation or problem that they are on. Another point, this kind of follows up on some of what Brian was covering last week on direct examination. So he had mentioned the importance of using exhibits appropriately. And this is another point for attorneys to keep in mind. It is completely appropriate to use exhibits on cross-examination. Two things on that I wanted to point out. One is, if at all possible, during the course of the mock trial, the attorneys on the team should all have an opportunity to introduce exhibits if it is at all appropriate to the role. So there might be times where it'll be really difficult for the attorney to figure out what exhibit to introduce through which witness. But in order to boost their points and their score, it's really important, if at all possible, for each of your team attorneys to be able to demonstrate familiarity with the process and how to introduce exhibits and then how to use them properly to kind of tell their story. So I think that's an important point on exhibits. The other thing about exhibits is make sure that the exhibit you're introducing through your witness makes sense. That exhibit has to be something within the personal knowledge or if it's an expert witness, that would be under that witness's training and experience. Don't just introduce an exhibit just so that you can show you know how to introduce an exhibit. That exhibit should be instrumental to the witness's story. When it comes to timing, there's a cumulative 20 minutes for cross-examination, and I think that's well versed and it's been covered in all of the mock trial rules. But one thing to keep in mind, in my experience with mock trial, one of the difficulties we had was particularly in cross-examination, where sometimes it can get out of, you can take them outside of kind of their plan, is there's 20 minutes total. But if one of your attorneys ends up taking more than their fair share, then you're going to have two other attorneys that are going to be on a limited time. So as long as the teams bear in mind that an attorney is judged on how they use their time, but also if that attorney doesn't have a lot of time, they're not going to be able to cover and get the score that they need for both their personal score and then for the team score. So it's just really important for your attorneys to keep track of, in a 20-minute time period, they have roughly 7 minutes, just under 7 minutes each. So if one attorney takes 10 minutes of the 20-minute time, it could result in an adverse impact on the other two attorneys. So I think it's just really important to keep that in mind and to share the time. There's a couple rules that are specific to the mock trial. One is, for purposes of the mock trial, an attorney can cover all of the areas that they think are important for cross-examination. In the real world, attorneys are oftentimes limited on cross-examination to the areas that have been covered on direct. But in mock trial, because we are dealing with a finite period of time and we're dealing with a very structured case presentation, there is no rule about that. So cross-examination can cover the areas that the attorney thinks are most important, and it doesn't have to be limited by what's brought up in direct. And that's something that is unique to the mock trial situation. One of the important ways for a cross-examination to be effective is to practice. Attorneys and witnesses should practice, and that means that they should take their witnesses through a cross-examination. So treat them as if they were the opposing side. And again, that makes sense if they're developing that relationship with their witnesses that I know that they will be doing for direct. One of the other benefits of that practice, or one of the other ways they can increase the benefits of that practice, is if the witness helps by the witness drafting, reviewing their own materials, drafting their own questions, working in conjunction with the attorney to kind of figure out what is the best way to phrase something, what is the best way to present the strengths and the weaknesses of their cases. The witness should not just be a recipient of that message, they should be a creator as well. So I think that's also an important factor when it comes to kind of that developing that relationship. And then finally, attorneys have an inclination or a desire to try to win in cross-examination, for lack of a better word. They want to try to score points off the witness. Just remind your students, in mock trial, they receive a decorum, a professionalism, and a kindness kind of overall civility point. It's important that they do their job well, but that they not be mean, because being mean to the other students does not show up well in the scoring, and it affects some judges more than others, but judges like to see civility in the courtroom, in the real world, and certainly in our mock trial world. So those are kind of the preparation points that we had for the attorney when it comes to cross-examination, and Judge Lorello has some pointers for witnesses.
Hey, Christina, could I ask a quick question before we move on to witnesses?
Yes, ma'am.
I know you talked about having time to practice, but for kind of my understanding of this is for cross-examination, they should kind of have an outline of what they want to cover, but they should also try to incorporate some of the stuff that happened in direct examination. How do you help them understand that they need to kind of listen and respond to conditions on the ground, kind of?
That's actually going to be one of the points we're going to cover it a little bit later, but just to answer that, so one of the things you do when you practice is you go through kind of your roadmap as an attorney, the areas that you want to cover, but it's important to first of all listen to the answers, and then second of all, it is very important to listen to the direct, because while you may have a good roadmap, your roadmap may alter completely based on the direct. And so we'll talk a little bit more about that later on in the presentation, but that's a very good question, because cross-examination is not nearly as prepared, obviously, as direct, because you're not in, while you're in control of you, you're not necessarily in control of how the other team is going to prepare their case. So we'll talk about some techniques and strategies to make a more effective cross.
I apologize for stepping on your presentation.
No, that's absolutely right. We were just trying to figure out how to make it make sense. So I think that was a good point.
Also a good segue, because just in terms of practice, obviously, when you're practicing before you're competing, you are going to be your witnesses. So I'm coming at this now from a witness's perspective. Your witnesses will be practicing how they would answer questions on cross-examination. And at competition, obviously, you will see different students handling cross-examination differently. So I want to talk a little bit about that, because in competition, you can often see a student, one of the witnesses, have this certain character or demeanor on direct, and then it gets to cross-examination, and then they turn into this entirely different person. They're not, friendly and warm, and they suddenly become combative. So from a witness's perspective, I actually don't recommend that. So if your student is playing the role of a witness, I think consistency in character between direct and cross-examination is important. I think judges notice it when the witness takes on an entirely different demeanor just because they're in cross-examination. Cross-examination doesn't mean the witness needs to be combative or hostile. The job is still to answer the questions that are asked, but try and answer them in a way that doesn't hurt your side too badly. If you're, by the time you're in competition, hopefully through your practice sessions, you have recognized the points on which each witness will be cross-examined. All of the witness statements are built to have something in them that is negative about the witness or inconsistent, and that's the point of cross-examination, is the attorney to draw those out, and then for the witness and or the witnesses, the attorneys that are on the same side as the witness to make those weaknesses seem palatable. So even on cross-examination, my advice is always for the witnesses to just concisely answer the question that's put to them. If it's a yes or no question, then answer yes or no. There's always sort of this inclination or desire to expand, and sometimes that's appropriate, but too much can be too much. So I think a little bit of explanation is fine. You will likely have someone try and cut you off, direct you that, just yes or no, please. And, that's always something, because there's redirect, that if there's a yes, but, or a no, but, that piece can always be picked up on redirect if it's important to the presentation of your case. But again, just stay in character, answer the questions as you would if being asked by a friendly party. And don't ever just talk to use up the other side's time. And I think that goes to Christina's point about civility points and sort of the professionalism and sportsmanship. It can be pretty obvious if you're just trying to chew up the other team's time by your behavior during cross-examination. So avoid that. Even on cross, exhibit sportsmanship and courtesy. Don't waste time or give narrative answers. Just focus on the question asked and answer it. Again, through practice, I'm sure that your students will know by the time of competition what they're going to get cross-examined on. And so it would be appropriate to sort of figure out a way to best frame that information, but it's okay just to also acknowledge the weakness. I mean, you have to be consistent with your witness statement. And so above all else, do that. And just a couple of things too, when asked a question, if your student as a witness doesn't understand the question, it's okay to ask the attorney to repeat it, or say, that you don't understand. I will note that sometimes I've seen students do that either as a gamemanship to waste time. That's usually pretty obvious, because if they suddenly understand the question when it's asked exactly the same way, which it may be asked exactly the same way because someone is reading from a script, it becomes apparent. But if the witness truly doesn't understand the question, it's okay to ask for clarification. And if on cross-examination the student doesn't recall the answer or recall the subject matter, it is okay for the witness to ask for permission to refresh their recollection by referring to the statement. If on the point of exhibits too, if the witness has asked something about an exhibit, it would be okay for the witness to ask to review the exhibit again, just to be able to answer the question better. Just because it's not right in front of the witness, it doesn't mean it's not okay to ask to look at it if it's been admitted into evidence already. So that's just sort of the advice on both preparation and answering the questions during competition. And then I'll come back after Tina's got some more techniques and pointers for organizing cross and asking questions on cross. And then I will have some tips on handling a difficult witness.
So now that we've kind of talked about how to prepare in general from both an attorney and the witness's perspective, let's really talk about crafting, because I think while it's referred to as organizing your cross, it's really crafting. There's an art to asking questions, and there's an art to pointing out both strengths and weaknesses in a case. So to the extent that your team, both your attorney and your witness, can really understand what are the strengths and what are the weaknesses of my character that I'm talking about, my witness, but also how does my witness play into the larger picture? So if we're talking about you're talking about a witness for the other side, because that's what cross-examination is focused on. What role does that witness have in the case at large? And not from their perspective, so not from the opposing side's perspective. How does that witness play into the case that our team is building? So if you can kind of identify what is the importance of that witness to our case, that's going to help you craft and organize your cross-examination. So cross-examination is generally used for two reasons. It's used to build or buttress the points that you're making as to kind of support your theory of the case, but it's also used to to poke holes in the opposing side's case. So you kind of want to craft your cross-examination with those two overarching themes. You want to build your own case up, and you want to poke holes in their case. So you strengthen you and you weaken them. That's kind of the idea behind cross. So with that said, you are going to figure out what is the best way to organize your questions. And generally, I recommend that. So for a 7-minute cross-examination, and it does go by quickly, your attorney should focus on a few areas for cross-examination. While it's a round number, generally speaking, 3. So what are 3 areas that you can use to either build your case or poke holes in their case? And I'm not talking about 3 questions, 3 areas. So you may be looking at bias as one of your cases, or one of your themes that you're going to attack. You may be talking about inconsistencies in their testimony, or you may be talking about their lack of qualifications, if it's an expert, their lack of personal knowledge, if they're a lay witness, but you're going to kind of focus on 3 kind of main issues. And then in those issues, you're going to figure out which one should go first, which one should go second, which should go third. Understanding that you may have to abandon one of those areas. So your attorney should know what is the most important and then what is the second most important. And generally that's what you're going to bookend. So you're going to do primacy and recency, right? First and last. And then maybe the other area that might be important, but not as important, put it in the middle of your questions. Now, when it comes to questions, there's a couple of different ways you can do it. Some attorneys want to do everything extraneous, extemporaneous, meaning they're going to go just off the cuff. Some of them are scripted. The better practice is to be somewhere in the middle. So create a roadmap, basically do bullet points, figure out what are the most important areas. What are the areas? Maybe write out, if you know you're going to use a specific phrase and you want to remember it exact, write that in your roadmap. But really a roadmap is guideposts rather than script. Because that way, if they get lost or they kind of need a break, a refresher, they can look down, they can think, they can refer to their roadmap, and it helps them to kind of have that, that refresher. But when it comes to the roadmap, the thing to keep in mind, I think this is the point that Carrie was making earlier. What happens that you, during the direct, you may have gotten a nugget, right? Like you may have a witness that said something. It has happened in mock trial. There have been witnesses that have just misstated something, and all of a sudden that's going to become key to your case, because once they say it, it's kind of in the record. And so it becomes a fact. And so your attorneys really need to be listening to to direct examination. They should be taking notes. They should be taking notes on their roadmap. So if that's the way to go, they have their roadmap, they have it pulled up as they're listening to direct. They may be drafting, writing themselves little notes, go back and cover it. The other thing is that your other attorneys, so I may be the attorney handling a particular witness, Judge Lorello is my teammate, she's going to be listening too. She shouldn't be staring off into space. She should be listening, helping me, helping to focus me. Maybe she's going to hear something that's important. That's the role of having a team. So that's kind of an important part of building cross. But really, as long as you have your roadmap and you're listening to the direct, because you may pick up that nugget, and listening to the questions on cross. When you ask a question, don't be prepared as an attorney to move to the next question, because it could be you didn't get the answer you wanted, or it could be you just got an admission that you weren't expecting. Like if they agree to something that you never thought they were going to concede, you may want to know that. And so it's important to listen to both the direct and then to their question, their answers to your questions on cross. And then pick the order you're going to go. Do you want to do chronological? Do you want to do substance? You don't have to do cross-examination in direct relation to how they did direct. So just because they covered topics 1 through 10 doesn't mean you have to go in the same order. You get to organize the information you want to bring forward in the way you think makes the most sense. So that's why that roadmap is really important. Then when it comes to how to ask questions, so the important part about cross-examination is you do not have to use open-ended. You as the attorney are in control of the questions a lot more than you are when you are asking direct. This is where you're telling your story, which is why you get to ask questions that should result in a yes or no question. The important part is, to the extent possible, encourage your attorneys to always ask a question that necessarily should result in a yes or no. That doesn't mean that you won't have witnesses that may try to kind of take you on a tear, and that's fine. Let them try to do that. If you don't like the answer they give, it is okay for you to ask the question again. And that kind of leads you directly to the last point when it comes to how to prepare and proceed with your cross-examination question. You can be tough without being mean. And in fact, when you are not mean and you are polite and pleasant, and you just bring them right back to your question, it's even more impressive than when you appear to be scoring points off a witness. Honestly, if the attorney can just say, thank you for that, I understand, but I'd like to ask you again, did you see the light was green as you approach the intersection. You know, whatever it is, you don't have to be mean in your approach. The attorneys don't have to be rude. And one of the things that attorneys will find when you're doing cross-examination, it is so exciting. And you start to get very excited and your voice may elevate and your speech pattern increases, which for somebody like, I mean, I'm guilty of this. As I speak and I get excited, I get really fast. So just remind them to take a deep breath, approach the question the same way they would if it was on direct, nice, even, tempered, but it is also okay to demand another answer. And by demand, I mean, ask it again. Don't be mean, don't be too controlling. I know I'm using that word mean, but that just is the impression I get. It's always more impressive to the teens when they have been cross-examined and run through the ringer because of the questions, not because the person was derogatory, rude, or condescending. I mean, the teens will know who does a good cross-examination, and it's always when they are asked very good questions that back them into a corner. They're the ones that can tell you that's an effective cross-examination. Somebody who's just making them, you know, raising their voice at them or trying to make them feel bad, those are never going to be your effective cross-examinations. So I hope that kind of answers some of the questions about how to organize and then how to proceed with your cross-examination. And now Judge Lorello is going to talk about how to handle your difficult witnesses.
All right, well, if folks have listened to Christina's wise advice about the point of cross is to build your side and weaken the other side. And so your witnesses should be listening too during competition. Like, what's this other team's theme, theory? How are they approaching this case? And that will, by the way, give your witnesses ideas, or should, about where they might get attacked, either to help the other side build their case or to weaken the witnesses' side of the case. And then they may try and be difficult based on what they know. Hopefully you won't, but if they're being difficult, meaning they're not answering the question, they're going off on tangents, how can the attorneys control that sort of behavior? One of the approaches, which I referenced in my prior comments, was the yes or no question approach. If you could please answer my question, yes or no. Hopefully the witness will comply, not always, or they may do the yes, but. It's okay at some point to interrupt the witness who's just going on a narrative. And again, to Christina's point, you don't have to be mean about it. You could just say, if I could just stop you right there for a moment, I would like you to direct you back to what my question actually was, which is X, Y, or Z, and then re-ask the question. Usually asking a question the second time, if they're trying to go off on a tangent or just start providing a narrative. Usually if you cut them off and then re-ask it, in my experience, that will usually work. They usually just kind of say, okay, well, yes or no, or whatever you wanted them to do in the first place. So again, I think that you can interrupt a witness that is being uncooperative. You just do it politely. In terms of impeachment of a witness who is either difficult or non-difficult, if they are saying something that is inconsistent with their statement, the best way to manage that is to impeach them with the witness statement, rather than arguing to the judge that they are engaging in an unfair extrapolation from the problem. Odds are the judges are not going to be, well, they certainly aren't going to be as familiar with the case as your team members are. And they may only have a surface level understanding, may have read the witness statements once. They are not going to have a grasp on the facts like you do, or what might be unfair extrapolation. It's putting the judge in, I think, a difficult spot, and certainly a difficult spot to rule in favor of anyone who's arguing unfair extrapolation. My guess is you'll probably just get a comment that, you know, that's noted or something. But the better approach, and just it's just better for not only for the judging side, but just to show the skills of your attorneys, is just to impeach them with a witness statement. You could, and you just do that by saying, asking to approach the witness. You can show them their witness statement, direct them to a certain area, just by page and line number, and then ask, isn't it true? Well, first ask them to identify that is their witness statement, that they prepared it at a time close to the event, and then that's their signature. And then say, isn't it true that when you prepared this witness statement, you said X, and today you're saying Y? The other thing is, you may not get a witness to answer the way that you want or expect the witness to answer, but that's okay. And part of it is because you may have accomplished your point just by the question that you asked. So again, the cross-examination style questions are, you know, isn't it true? They're more statements with a question mark at the end, by saying, isn't that true? Isn't that correct? Or something along those lines. And you're just trying to get the witness to agree with what your assertion is in the question. And oftentimes you've made your point just by asking the question. Or if there's really a non-answer, there's always an argument that can be made in closing. Like, you remember when I asked this witness this question and the witness didn't really want to answer, they went off on this other story, and then perhaps you can make an argument in favor of your side on that. So I think the biggest tip for attorneys is don't get ruffled on cross-examination if the witnesses aren't answering how you expect or behaving how you expect. If you have like the 3 areas like Christina suggested, just go back to that. This is your plan as the attorney. And you're obviously going to face students who you haven't dealt with before, because now you're in competition. You're not practicing with your own teammates, and they're not answering how your teammates would have answered the question. So just go back to your plan, the things you're trying to do, building your case, weakening theirs, and don't get ruffled, because there's strategies just that you can employ regardless of what that witness is doing. And then on the witness side, don't get ruffled. You know, even if the attorney coming at you is taking an angry tone, you know your witness statement and you answer the questions, and to the extent you need to be rehabilitated, first of all, you probably know what your weaknesses are anyway, and it's going to be the job of the attorneys that are on your side of the case to rehabilitate you on redirect. And I think I saw something pop up in the chat, Carrie. I don't know if.
Yeah, Shannon asks, what do you think about the objection as an answer being non-responsive? Do you want to explain that a little bit more, Shannon?
I think we can probably, Shannon, if we don't answer, if we're not responsive, let us know, because we were actually going to move into responding to objections was our next category. So if the answer is not responsive, I mean, I suppose you could object. If I was playing the role of an attorney, I would actually just highlight for the witness I'm examining, well, that doesn't really respond to my question, so let me ask again. Because the more you can keep the judge out of something that you think is not responsive, in my opinion, the better. I think the judge is there more to rule on objections like hearsay or other questions regarding admissibility versus objections based on the content of the answer. I don't know, Christina, what do you think?
No, I was thinking the same thing. And I also think that you run the risk if a witness tries to either, you know, strike because a response is unresponsive, many times it is responsive. It's just not the way you wanted it. So a witness who says, yes, but, and then gives an explanation is still responding to your question. They're just not answering it the way you want. So then it is a responsive answer. But I think that the judge makes a good point. It's probably more effective to say, I understand that. Thank you very much for that answer. However, I'm going to ask the question again because that really didn't answer my question. And you're fine on doing that. And I think it's more important for the attorney to show control rather than try to cede that to the judge. And actually, we were talking about that when we were preparing for the session about is it ever appropriate to ask the judge to direct the witness to respond? That is always something that you can do. It's not something that we recommend, and there's a couple reasons why. By doing that, a counsel is kind of ceding some of their authority to the judge. I mean, we all recognize the judge is, the final arbiter, gets to make those decisions. But as an attorney, I want to look like I have control. This is my case. I'm controlling it. I'm running it. I don't want the judge to tell that witness to answer me, because then it makes it look like I can't get my own answers answered, my own questions answered. So it's just more appropriate to just repeat your question. And then eventually, if they don't answer, then you can say, move on. And then in closing, reiterate, this is an answer. This is a question that was never answered. And it was never answered because the answer is, and then you get to control it. In addition, so in the real world, when it comes to that question of, Your Honor, would you please direct this witness to answer my question? There are very limited times that that's going to be used in the real world. And most of the time it's when you've offered some sort of like immunity. So the reason why the court is ordering the witness to comply is because they've asserted like a Fifth Amendment right. So they have basically, or they've issued a privilege objection. So they have done something where they are telling the judge, they are communicating, I'm not answering it for some reason. And the judge is making a legal determination that they will answer. So that's why, that kind of approach is just not generally recommended in mock trial. And I think that kind of covers, Shannon, your question, but let us know if that didn't address it before we kind of move on a little bit. We want to make sure.
And just to give you an example, early in my career when I was doing a hearing with witnesses, and I asked this witness a question and she clearly didn't want to answer it. And I knew why she didn't want to answer it, because it was not a comfortable question for her answer. And it was really, there was no win for Suji. So it was just a bunch of non-answers. And I said to the judge, can you direct the witness to answer my question? And he said, you've made your point, which sort of goes back to my advice of, sometimes you just make your point by answering the question or arguing later that the witness would not answer your question.
So we just have a couple other points we wanted to hit here before we finish up. So on the issue of objections, you're going to have a whole session kind of about what are the most important objections to know, how to argue them, what is the textual basis for them, and then what is like a factual application of them. But for purposes of cross-examination, I think this is also what is true for direct. When a team is approaching a trial and they want to get certain information into the record, they should know, why do they want to get this information in the record? And then they should know, why is it admissible? So if you can answer those two questions as an attorney, I am attempting to introduce this evidence because it is important to my case for this reason, and I know it's admissible for this reason. So if you can answer those two questions, then you are completely prepared to respond to objections, because that is it. While it's nice to be able to cite to the rules of evidence, and that obviously is important, the reality is factually and legally, you need to be able to say, this evidence is important to my case because of X, and it's admissible because of Y. And if you can answer those two questions, you can respond to any objection. On the flip side, so how do you know when to object? It's when you can say, this evidence should not be part of this case because of a certain reason, or sometimes there's a strategic reason to introduce or to object. It's when you're trying to break up a case. That is important when it comes to your presentation of a case. But the reality is there should be a valid basis for why you're objecting. And it should be more than just to interrupt or interfere with the case. But when it comes to responding, those are the two questions you need to be able to answer. So if you can do that, you can respond to an objection.
And by the way, the response is never, it's in the witness statement.
Right. There's a lot of information that may be in a witness statement that's not admissible. The witness statements contain clear hearsay. Most of the time, there's one or two witnesses that have clearly objectionable material. That is one of the things that the students are being asked to be able to identify. They're supposed to be issue spotting and then be able to figure out when and where to object. And by the way, just because something is objectionable doesn't mean you want to object. Sometimes there is a strategic reason why you want something in the record. And so it's okay to overlook clearly objectionable material. Again, if you're going to do that, then you should be able to answer that at least the first question. Why is this important to my case? Because it may be objectionable and it may not be admissible if you were to object. But if you say there is a valid reason why I want this in the case, then it's okay to forego an objection. So that's important. That's part of objection practice. The important thing about objections is that, again, because cross-examination is all about exerting control and trying to structure your case around the opposing party's case, try not to end with an objection, especially if you lose it, right? Like, you don't want the court to sustain an objection and you not have any further questions. So if you know you're at the end of your cross-examination and the judge sustains an objection, so you don't get an answer, have something as the attorney, go back and ask something that you know you can get an answer to so that you finish your cross-examination on your own terms. It's important that you end the cross-examination. So, and I think with that, the judge has one final point about ending the cross-examination.
I think the only other point I wanted to make is that I have seen witnesses respond to an objection. And so the attorney will object and the witness will start explaining to the judge why it's admissible. Witnesses should not do that. Making and responding to objections is solely within the purview of the attorneys. So
Right, I'll make the last point. I just have one more point, which is know when to stop.
Oh, sorry. Yeah.
I was like, sorry. Obviously I'm the one who doesn't know when to stop. So when it comes to cross-examination, we talked about how there may be this roadmap and you may have some beautiful questions that you want to focus on. If you get your nugget, you get that thing that makes your theme, and it's like 3 questions before you are scheduled to be done, it is okay to stop. As an attorney, it's more important that you know the importance of the information that you just elicited than it is for you to finish those last 3 questions. So cross-examination is all about crafting a response, building your case, poking holes in their case. If you've been successful, it is okay to stop before you finish those last couple questions you had intended. Know when to stop.
Now we know when, now we have known when to stop, and we're stopping.
Any questions before we wrap up? Okay, next week we're covering objections, and I'll send out a link, and I will actually also post this video later. I appreciate our speakers for being here today and our teams for being here today, and I look forward to seeing you soon. Bye, everybody.
Bye.